All right, let's talk about something pretty much everyone can relate to, a neighborhood dispute over a parking spot. But this isn't just some story about a nasty note left on a windshield. No, this is a 2-year-long war that involved lawyers, thousands of dollars in fines, and even a dramatic standoff with a tow truck.
And this is where it all ended up. $2,544. That is the final bill a condo owner had to pay in fines and fees. And the whole thing started because of one single parking space.
So you gotta be asking yourself, right? How on earth does a simple parking tiff spiral into that? That's what we're gonna get into. We're gonna trace every single step of this thing, using the official court documents to see exactly how it all went so wrong.
And you're not going to believe this, but this entire 2-year saga with that huge bill at the end, it didn't start with a lawsuit or some angry confrontation. Nope. It all kicked off with one little piece of paper, a notice, politely called a friendly reminder.
Okay, so let's meet the main players in our parking drama. On one side, we have Michelle Ruffo. She's owned a condo in the Reflections in the Catalinas community since way back in 2005. On the other side, her Homeowners Association. Now, Ruffo was convinced she had the right to park in certain spots because of these informal deals she'd had with her neighbors for years. The association? Well, they were about to enforce the rules, by the book.
So how do you get from a friendly reminder to a full-blown legal judgment? Well, it didn't happen overnight. It was this slow, methodical ramp-up of warnings and then fines and then penalties. Let's actually walk through the timeline to see how this thing snowballed.
Okay, just look at the pacing here. It starts off slow, right? August 2016, you get that simple reminder. For months, it's just warnings. Then, March 2017, the first fine finally hits, just 50 bucks. But then, things start to speed up. By June, the fines are jumping by $200 at a time. A month later, the HOA really raises the stakes. They cut off her access to the pool and the gym. And then, bam! In one single month, September 2017, they pile on a staggering $1,400 in fines. By the time this all gets to a final hearing, the total has ballooned to over $2,500.
Now, before this thing ever saw the inside of a courtroom, it got real out in the parking lot. The HOA called a tow truck, but according to the official report, when the driver shows up, Ruffo is in her car and just refuses to get out. She's literally sitting in the driver's seat as the guy starts hooking up her car to tow it away. She even ended up calling the sheriff's office. I mean, it became this incredibly tense, personal standoff that just shows you how bad things had gotten.
And that right there, that standoff, it really gets to the heart of what this was all about. Because this was never just about a car. This was a head-on collision between two totally different ways of looking at how a community should work. You know, the informal handshake deals you make with your neighbors versus the cold, hard official rules that are written down to govern everybody.
Let's just break down the two sides so it's super clear. Ruffo's whole case was built on history and personal relationships. She's saying, hey, I've had written permission from my neighbors for years to use their spots. As far as I'm concerned, this is a done deal. The association, though, their position was simple, and they never wavered from it. They said, look, the community rulebook is the only thing that matters. It says you park in your assigned space, period. Any private deals you made, don't change the official documents everyone agreed to when they moved in.
And that rulebook the HOA keeps talking about, it has a name, and this is absolutely key to the whole story, the CC&Rs. And here's the thing you have to understand. CC&Rs aren't just some friendly guidelines. They are a legit, legally binding contract. And the documents for this community were crystal clear. If you want to change who uses which parking space, you can't just make a deal with your neighbor. You have to submit a formal amendment, signed by everyone involved, and get it approved by the HOA board. That was the official process, a process Ruffo never even tried to use. So, as you can imagine, this whole mess eventually landed in a formal administrative hearing. This was on September 18th, 2018. It was finally the chance for both Michelle Ruffo and the association to go in front of a judge and lay out their entire case.
So Ruffo came in with 4 main arguments. First, she really doubled down on her claim about having written permission from her neighbors. Second, she said, look, a lot of the time it was impossible for me to even use my own spot because it was always being blocked. Third, she felt that the fines were just a form of personal harassment and retaliation. And lastly, she argued that the violation notices weren't even valid because they didn't have any photos to prove she was in the wrong spot.
The association's case, on the other hand, was just laser-focused on procedure. Their argument was really simple. The CC&Rs are the law of this community, and they say you park where you're assigned.
They basically said any side deals between neighbors are nice, but they're legally meaningless. They showed evidence that they followed their own enforcement policy to the letter, from the first reminder to the final fine. And the real kicker? They pointed out that Ruffo never once tried to use the official process to get her parking situation changed. So there you have it, two completely different views of the world. Ruffo's case was all about practicality and personal agreements. The association's case was built on a rigid, almost robotic adherence to the legal documents. The judge had to figure out which one was going to win. So the big question, after all the testimony, after looking through 2 years of letters and violations, where did the judge actually land on this? And wow, this one quote from the final decision, it tells you everything you need to know. The judge basically said that, look, while Ruffo's situation might seem understandable on its own, if you applied her logic across the whole community, it would be total chaos. If anyone could just make a private deal that overrode the official map, nobody's spot would be safe. It would completely destroy the system that lets 136 families live and park together. And with that, the final verdict was completely unambiguous. The judge ruled entirely for the Homeowners Association. Ruffo's petition was denied, the fines were upheld, the rulebook won. So what can the rest of us actually learn from this? This incredibly expensive parking war. This really isn't just one person's story. It's a huge cautionary tale for anyone who lives in a community with shared rules. Here are the big takeaways. First, and this is so important, that super thick packet of CC&R documents you get when you buy a place in an HOA, it's a real, legally binding contract, not just a bunch of suggestions. Second, a friendly handshake or even a written note from your neighbor is great, but it has zero legal power when it goes up against the official rules. Third, if you have a real problem, use the system. There are formal processes for a reason. They protect you. And finally, do not ignore the small problems. A $50 fine that you just brush off can, as we just saw, grow into a multi-$1,000 legal nightmare. And that kind of leaves us with one last thing to think about. Just think for a second about your own neighborhood or your building. What are the informal, unwritten rules that everyone just kind of goes along with? And after hearing this story, you really have to ask yourself, are those little arrangements truly safe? Or are they just one friendly reminder away from completely falling apart?